Welcome to You Can't Say That in Court, a podcast by Rise Women's Legal Center. I'm Vicky Law.
And I'm Stephanie Melnick. We are your hosts in this conversation about survivors of violence navigating the BC family law system. We recognize that this system is colonial and causes harm to families, and that disproportionately impacts Indigenous people.
By speaking more widely about these harms, we hope to raise awareness about the challenges that survivors face as they navigate the colonial family law system. This podcast is our attempt to collectively identify the barriers and ask for positive changes to be made. Thank you for joining us. Our podcast series will discuss difficult topics such as gender-based violence and intimate partner violence, including physical, sexual, emotional, psychological, and financial abuse. Please be aware that this is a thread that is woven throughout all the episodes, and we hope that you will take care of yourselves however you need.
Hello, everyone. Welcome to episode 6, where we are continuing to talk about some of the challenges that it takes to navigate family court in BC. And we can't talk about that without addressing, once again, so many myths and stereotypes that persist about family violence.
But before we get into this topic, Stephanie and I want to take a huge moment to thank all of our listeners who've tuned in all this time. The support and responses we've received so far is greatly appreciated, and we want to give a huge, big thank you to all of our listeners.
Yeah, thanks for that, Vicky. I echo the sentiment. Okay, so today we are switching things up a bit with respect to format. We're going to try a bit of a question and answer because we have a guest again today. We're so excited. Vandana Sood is a colleague of ours and a supervising lawyer at Rise, and she is going to be talking about some of these ideas we've had and making them kind of practical, seeing what they look like in practice. So, Vandana, welcome.
Oh, thank you so much, Stephanie. I'm so excited to be here with you and Vicky, and to talk about myths and stereotypes today. Maybe I'll talk a little bit about myself. I've been working at Rise since we opened, which is kind of crazy. We opened in 2016, and I've been here all this time. I practice primarily in family law. I used to teach law students, and now I take on some files and I work with some staff, and it's great. I love working at Rise.
Yeah, that's fantastic. We love working with you too. You may know that in some of our past episodes, we've had a number of themes kind of running through the episodes. This is our 6th episode, and I think it's the right time to be getting a bit more practical and talking more tangibly about problems that court users face when they're going to court. So self-represented litigants maybe, or unrepresented litigants, as you like to say, Vicky, trying to make the distinction between people who can choose to not have a lawyer with them in court, or who are left without any resources to hire a lawyer, and their choice. They don't have the choice. They have to be in court self-representing. And then having an added layer of family violence, where we all maybe understand that a little bit differently, or there's a different willingness to engage with the context of family violence. So that means the lawyers that are involved, support workers, judges, and even the clients themselves. So in some of our past conversations, we've talked a bit about these different levels of willingness to engage with the context of family violence. And then there's that ongoing theme that Vicky and I just keep bringing up around myths and stereotypes that are really working against a lot of folks who are in court. And that's why we invited you on, Vandana. You've recently dealt with a case where courts had to grapple with some of these myths and stereotypes. And maybe we'll just start with a bit of background on that. What can you tell us about the case?
Yeah, thanks, Stephanie. And I mean, everything you're saying, it makes so much sense. And the thing about myths and stereotypes is they're the kind of thing where you don't always necessarily notice them until all of a sudden you notice them, and then you really can't unsee them after that. So that's kind of what we were trying to do with this case. I represented an unrepresented litigant, the mother, and the case for the, anyone who actually wants to look it up, is KMN and SZM. It was in the BC Court of Appeal in 2024, number 70. And the thing about this case is, it really asked two really important things. And the thing that, we were really concerned about wasn't myths and stereotypes in the beginning. It was about the impact of a child witnessing violence between in this case, their parents. And when one parent is violent against another, how does this impact a child? And should the amount of parenting that perpetrator has be changed? And so what had been happening in the courts was they weren't necessarily doing this. They tended to say, oh, well, the violence wasn't directed at the child, so we're still going to give them, let's say equal parenting time. But that's not what the law said. So in this case, there was, a lot of history of criminal charges against the father for, allegedly physically hurting the mom while she had the child in her care. And yet at the trial, what the judge ended up doing was deciding that he believed the father rather than the mother. And what was, really stood out to us is he said that when she would call the police to report an assault, that her calling the police was, and he used the word weapon against the father. So this really jumped out at us as an example of a myth and stereotype.
Right.
Yeah, I
Yeah,
just
that
want
was
to
kind of a shocking piece. Yep.
Yeah, I just want to tell for our listeners, for those of you who aren't familiar with the family law system, the trial level was held at what's called the BC Supreme Court. And then Vandana represented the mom and appealed the decision and that's when it appeared before the BC Court of Appeal.
Yeah, exactly. And because what the judge did at the first trial decision was what he's supposed to do is decide what parenting is in the child's best interest. He's not supposed to think about anything else, not about what either parent want or why the parents might be mad at each other, or even in this case, he needs to decide what is best for the child. And one of the factors is that if one parent is violent against another, it might not be good for the child.
Right.
Yeah,
And
and
I
I
think
think
that is one of the myths. Yeah, go ahead, Vicky.
No, I was just going to say that's one of the myths. We're going to say the same thing that we have consistently talked about in previous episodes. And something that I think we all like to highlight, which is when courts decide parenting time for a perpetrator of abuse, without any parameters or safety precautions, it's almost as if we're placing the need for a parent's ability to see the child over the child's safety or over the mom's safety.
Yeah, and that's so significant that the child's safety is not the first priority when these decisions are being made. And the law says it should be the first priority, but that's not, oftentimes, not all the time. That's not how these court decisions were being made. So we wanted to go up to this higher court, the Court of Appeal, to see if we could get some kind of stronger decision on that.
Yeah, I think you were really right on, Vandana, when you're mentioning that when we don't see or recognize the stereotypes or the myths that are being relied upon, then that's when things get clouded, and that's maybe where that test of best interest for the child is not being held as paramount, because we're being misguided by myths and stereotypes, and one of which is, like you're saying, what is the right parenting arrangement when there's a context of family violence or a history of violence in some way. Are there some other myths that were highlighted through your work on this case that you were able to recognize at the trial level?
Yeah, that was what was really kind of exciting and unexpected about this appeal decision is the Court of Appeal decided to actually talk about the myths and stereotypes and list some of them. The overarching myth and stereotype that they were really getting at is that specifically women allege violence to get some kind of advantage. in a family law proceeding. And these can be different kinds of supposed advantages. One can be, allegedly to try to keep a child away from the other parent, in this case, the father. Another advantage that's often thrown out is, oh, you're just alleging violence in order to get more money, more support, more property division. And so it's just sort of this overall myth that women as well as mothers, quote unquote, weaponize the legal system as if they would even have the ability to do that. But that's this overarching, almost unconscious myth and stereotype that has run through a number of family kind of court decisions.
So yeah, about the advantages that Vandana just listed, I think we briefly talked about that in our past episodes with Haley and probably Stephanie Hodgson as well, where there really is no advantage that we can see for survivors when they allege family violence because of these myths and stereotypes, because of all the barriers and challenges that we have identified, such as people not believing them, again, other myths and stereotypes being questioned. Why didn't you call the police? Why didn't you, call child protection services? And in this case, I know that the mother did call the police or go to the authorities for assistance. And in fact, that was used against her.
And she followed their instructions whenever they did. And that's in the case. The police would say, do this, or the Crown would, and she did what they said. And they were even trying to hold that against her. So it was definitely a much more obvious example, I would say, of a myth and stereotype of that this mother, in this case, is doing all of this on purpose for some ulterior motive.
Yeah, and in fact, we have discussed previously that there are almost only disadvantages, right? Bringing up all of this context almost has nothing but disadvantages. And so that's why it's so encouraging that the myths were recognized at the higher court. I think that is incredibly encouraging. And Vandana, I'd love to hear more about why you think it's important that this is recognized, like in the context of a court decision.
Well, and we didn't go into this appeal expecting it to have this kind of impact or have, these sort of important findings, but it was the first time that in family law that this myth had been recognized by an appeal court. And it hadn't even really been recognized in BC in the Supreme Court or the appeal court. And the Court of Appeal went into quite a bit of detail about it. They even listed like a number of common myths in the court decision, even one like that a credible woman would leave the relationship. And so it was really encouraging that they listed these and were recognizing them as myths. What they said and what they instructed courts is that it's wrong to base our beliefs or for a court to make their decision about violence on something that's not true, which is a myth or stereotype. It has to be based on evidence. They recognized that family violence is difficult to prove, that often it's just two people with no witnesses. And what they said about it that was really interesting is they said, just because someone can't prove family violence in a court in terms of putting the evidence doesn't mean it didn't happen. So, having all of these things written out so clearly and decided by the Court of Appeal in BC is going to be, really impactful for survivors coming forward in their family law cases and hopefully not finding themselves having to deal with and handle, oh, this judge isn't going to believe me and maybe I shouldn't talk about family violence today.
Yeah, all of these pieces feel really huge, like the recognition that just because family violence wasn't it doesn't have the ability to prove the context of family violence, doesn't mean it didn't happen. I think that would be incredibly validating for a lot of people who've gone through court proceedings and not felt believed or lacked evidence that the courts could recognize it. And it kind of echoes back again to the name of our podcast about the courts haven't been equipped properly with that ability to hear those contexts of family violence, because typical evidence that historically has been used in court doesn't necessarily exist for that context. So you said something earlier that was super interesting too about indirect family violence and children being exposed to violence. What was the importance of that piece?
Yeah, I mean, that's what the case was originally about. Our family
Right.
law here in BC, and you probably talked about this on the podcast before, um, brought in a definition of family violence for parties who are going into family court, and they defined all the different kinds of violence. And the obvious one that we can all kind of recognize is when someone physically hurts another person. That's direct family violence. So direct family violence is against one individual against another. Indirect family violence is important in the definition because it applies to children who are exposed to violence. So if you can imagine, um, you know, one parent, uh, hurting or physically assaulting another one, and the child is in the room, or the child is in, one of the parents' arms, or like that's obviously going to have a very real and negative and traumatic impact on that child. And that's why it was recognized in the law as being one type of family violence. But um, one of the things we had seen, like I said earlier, is this one branch of family violence wasn't really being taken into account when deciding, when a court would decide what the parenting schedule should be. For example, like I said, they would say, oh, it wasn't against the children, so it's not relevant. We're going to make it equal parenting time. So what we were seeking to do, yeah, is just have the Court of Appeal say, this is violence, and this has to be taken into account when deciding what's best for children, because that wasn't happening.
I think we have courts, especially like the Supreme Court of Canada, recognizing in another case called Beringret that family violence has an impact to children in both direct or indirect exposure. And witnessing violence is one form of indirect family violence, but also just being around it, knowing that a parent is experiencing family violence can have a huge impact on children. And research has shown that children exposed to intimate partner violence or family violence are more likely than other children to be aggressive and have behavioral problems and have other symptoms than those who did not experience family violence in their homes.
And I mean, this goes back to our earlier conversation of prioritizing children's safety and putting them in an environment that's best for them to grow up and to thrive. If they're in an environment where there's, constant, like for them, from their point of view, extreme tension and stress and conflict and violence and anger, that child is not safe. And that should be the primary consideration. And that is what the law says it should be. So we just wanted to make sure that this is what would be happening going forward.
I just want to bring it back to something you said earlier, Stephanie, about like the ability for the courts to be equipped to recognize these forms of violence. I think as we have said before, the legal system is very good at recognizing isolated incidents, right? So someone punches someone else, that's an assault. We see that happening. It's one incident, it may not happen again. But that doesn't really happen in family violence because, as we have said before, the pattern of coercive and controlling behavior and the difficulties for survivors to show that to the courts, because it may never ever be physical. It could just be psychological, not just, but psychological, emotional, and financial abuse. And how there isn't one isolated incident. and the challenges of being able to present that history over a number of years to the court to have them recognize and acknowledge it's family violence is very difficult.
And I think one of the things that we sought to do with this case is, even though this isn't what the law said, there seemed to be this unspoken assumption that parents have rights to time with their children. And the law is very clear that nobody has a right to time with their children. It's all related to whatever's in the best interests of that child.
Oh my gosh, that's a lot. There are so many layers to it. And Vicky, I'm so glad you brought up coercive and controlling behavior, and Vandana, to bring it back to really centering what is best for children. I think those two pieces, I think without those two pieces, actually, that's where myths and stereotypes can thrive. Because if we're not holding that pattern of behavior over time, as well as the impacts on children, and that we all have collectively decided that our laws are what they are because we collectively believe that children should be able to grow up safely and in a healthy environment. Yeah, that's where those myths and stereotypes can seep in, I think, and then work against us, on every level. It's really insidious. So kind of in an adjacent area, like in the criminal court context or criminal code context, when it comes to myths and stereotypes, there have been some developments, especially around sexual assault law. Do you have a couple of insights about that, Vandana?
Yeah, I mean, I won't get into it too deeply because the law is quite developed in criminal law on myths and stereotypes. But what is important is that they've also recognized that myths and stereotypes do exist in sexual assault law when it comes to gender-based violence. And what was significant about our case is, in family law, it was the first appeal case that really talked about myths and stereotypes. So we're starting to see that sort of progress in the family system, where it's already been in the criminal system for a while, most recently at the Supreme Court of Canada.
Right. I love that you say, we're not going to get into this too deeply. I think that's been a kind of another recurring comment that Vicky and I have made. We're like, we're just scratching the surface on all these things. And yeah, we have additional resources that we can share with listeners if they're interested in learning more. But I really appreciate you touching on all of these elements, because they all kind of work together to move us in the right direction. And on that note, what do you think this case, specifically KMN, is going to do for the future of family law cases? I mean, you've talked a lot about, yeah, how it's been a bit groundbreaking and unexpected, that you were surprised with some of the outcomes that came with the decision, but that is going to change the future of family law.
And I'm hopeful that it will change it. I think we have to be realistic about the degree to which it will change it. But what the case does is it tells courts not that they tell them that they can't make a decision based on a myth or stereotype. You can't decide, I don't believe this woman because she's doing this on purpose, without evidence. If they're going to come to some conclusion that someone made a false claim of violence, which I want to make clear is extremely and extraordinarily rare, like you were saying, Stephanie. And if, in fact, if anything, family violence is highly underreported, not overreported. But what the court said is, if that happens, the courts have to be super clear to explain why they're making that decision, and that it's based on concrete evidence. So the first thing was to recognize for the future these myths exist, and kind of be careful, courts, don't rely on these myths and stereotypes. And then the other one was really what the main purpose was in the beginning, was a much stronger kind of reminder to courts that indirect family violence is important, actually critical to a child's best interests, and just because you say, I can see that indirect family violence occurred, doesn't mean you can then say, but it doesn't matter and parenting time should be equal. What they said was it does matter and it's important, and courts have to consider it when deciding the on the ground part, which is what should the actual parenting time be? How much time should the perpetrator have with the child? Is that not just safety, because safety is like the bottom, right? Like we're not just trying to avoid harm, we're doing more. We're trying to promote a positive. What we're trying to do is promote best interests. And that's really like the main purpose of what the courts need to do when deciding parenting schedules.
Yeah, amazing. These are not small changes, that have happened with this decision. I know that you're cautiously optimistic, and I really appreciate you saying that, things won't change quickly necessarily or dramatically, but it really does feel like a reason to have some hope. And if nothing else, this decision has sparked a lot of conversation, like across the country. And I think that is also huge. Again, the whole point of using a podcast as a platform to just increase the conversation and increase everyone's understanding. So thank you so much, Vandana, for taking the time with us today. I know that I think we're saying, Vicky, with every guest that we have, we're like, we have to have you back. There are so many other things we can talk about. And so this stands here as well. It would be lovely to keep talking about this sometime. If you have the time to share.
Oh, I'm so grateful that you invited me. Thank you so much. And yeah, I'd love to be back. It was a great conversation.
Excellent. Okay, so we are going to keep talking about all of these themes that, again, we keep identifying with every episode. But the next episode, Vicky and I would like to get into a little more detail around survivors' experience with financial abuse, even after separation. There are lots of nuances, and it's going to be an interesting analysis, I think. So we'll specifically talk about misunderstandings around what financial abuse is and some of the legal issues that are involved.
Thanks to everyone for listening to episode number 6 of You Can't Say That in Court, and we will see you in a couple of weeks. Bye for now.
Everything that we have said today is not legal advice. If you or someone you know needs legal advice, please consult with a lawyer. We want to acknowledge that this podcast would not be possible without the generous contribution by Women and Gender Equality Canada, Femmes et Égalité des Genres Canada.